Morning.
Good morning, everybody. My name is Wendy, and I wanted to let you know that the recording has begun. It's now 10:30, and I'm going to let Marion take the floor from here.
You don't seem to have all of the pictures up yet.
Yeah, sorry, I'm having some technical difficulties. Bear with me. Can you guys hear me?
Yes.
Okay, well, at least you can hear me.
This is Bill Abood. I don't see that my camera's working somehow. Can you hear me?
Yes.
There's an icon at the bottom of the screen that should say start video.
Thank you. Yep, there it is.
Yeah, it's just giving me a gray option or a blue screen. And my light is on my laptop here.
Wendy, I've messed it up. I think you're-
I'm gonna try leaving and coming back in and seeing if I messed something up when I logged in. Just bear with me.
We'll sit here for a bit.
It's a familiar face.
I'm getting one person at a time on my screen. There we go. Evidently, I don't have a face.
Who
Now
now?
I do. By golly. We're missing Mr. Brucia.
Like your flag there, Jim.
Yes.
Hi, Jim.
My son-in-law put his up out in Bangor and it got stolen the first night.
Wow.
So
Yeah.
mine's staying inside.
Are we waiting for the Brucias? I think I thought I saw their name pop up for a second there. I don't know.
Yeah, okay, I didn't. Yeah, he's trying to get back on. He lost some, I don't know, the picture or something. So he cut out and is trying to get back in.
Okay.
Give him a few minutes. We are recording, by the way.
Well, I am being good.
That's good.
If I look like I've gained weight, it's my camera.
Absolutely. Any word from him? Sorry about this.
Do we have a phone number for him? Maybe we can get a,
I don't know if Wendy doesn't. Yes, I'm sure she does because that's on the application.
do we have a phone number for him? Maybe we can get a,
Yes, we do.
Wendy?
Yes, do you want me to go ahead and call him?
I don't know if Wendy does it.
My-
Yes, I'm sure she does.
My phone's ringing, so that might be him. Hold right on, okay?
Application.
If that's not him, I have a number for him.
Disconnecting now. I'll call him as soon as I hang up with you, and if there's any trouble, we'll buzz you back. Thank you. Thank you.
Yeah, I'm in.
Okay, yeah. She was just admitting both of us, she said. Okay, I'll talk to you after.
All right, folks, sorry about that. I
Ready to
don't know
go?
why I'm not really sure why my computer is not, my video isn't
Okay, not
working, but
important.
oh, there we go.
Thank you. Goodbye. What is the number 1-516-887-6567? Who is that?
That's me. I had trouble with the computer as well.
I don't have a name on that.
Hold on,
That,
hold on. Can you hear me?
I can hear you, but I have no idea what your name is.
My name is George Brucia, and
Thank-
I dialed in on the telephone because I was having trouble on the computer just to make sure I didn't miss anything. If you want, I'll hang up on the telephone.
That's fine. You can do both. That's
Okay.
no problem. Plenty of room. Okay, let's go then. Welcome to the May 21st, 2021 meeting of the Knox County Board of Assessment Review. The meeting will come to order. This is a public proceeding, and unless the board specifically votes to go into executive session, you have the right to hear everything that is being said and to look at all of the exhibits that are offered. Please notify the chair if you are unable to hear or to see. The board expects that this hearing and the subsequent deliberation will take no longer than an hour and a half in total. There has been a question raised about the two Robinsons on the board and another representing the town. I assure you that I am not involved or related with either of them, and I do not believe that they are related to each other either. There just happen to be a whole lot of Robinsons in the state of Maine. The board
I'm
works.
not related to any Rockland Robinsons, and I wouldn't admit it anyways.
Okay, very good. Wes, you're good.
I'm not related to any of the other Robinsons either.
Thank you. Okay, so we move on. The board works from a prepared agenda. There is one item on today's agenda. That is the hearing of the appeal of George and Susan Brucia to this board of the denial of their appeal to the Cushing Board of Assessors in the matter of the assessment of their property at Davis Point Road, map 29, lot 36. Any person wishing to address the board may do so in accordance with the following procedures. The board will initially confirm with the appellants and the assessor's agent the current assessed value of the property and the requested abatement amount. The board will then open the public hearing and ask the appellants to present their case briefly and concisely. The board has studied the submitted material, so please just present your points with your proof of them. The board expects this part of the hearing to take no longer than 15 minutes. The board members will then have an opportunity to ask questions of the appellants, and the assessor's agent will have an opportunity to ask questions of the appellants. The board will then ask the assessor's agent to present his case briefly and concisely, presenting his points and proof of them. The board expects this part of the hearing to take no longer than 15 minutes. The board members will then have an opportunity to ask questions of the assessor's agent, and the appellant will have an opportunity to ask questions of the assessor's agent. When there's no further testimony from either side, the board will then close the public hearing for approximately 5 minutes to give persons who wish to listen to the board's deliberation time to log onto the site provided for that purpose. The board will then deliberate and make a decision on the abatement appeal. Following a decision of the appeal, toward the end of the meeting or at a subsequent meeting shortly hereafter, the board will prepare a written decision that will be mailed to the applicants within 10 days of the board's vote. The board may receive any oral or documentary evidence, but such evidence is restricted to the subject matter of the agenda item. The board has studied the submissions of the parties. The board shall exclude irrelevant, immaterial, or unduly repetitious evidence. Citizens shall refrain from interrupting other speakers. Please raise your hand if you wish to be recognized and remain on mute when not speaking. This meeting is being electronically recorded, and it is very difficult to hear what's being said when multiple people speak at the same time. Citizens shall avoid personalities and conduct themselves in a civil, courteous manner expected of all meeting participants. Speakers should address questions through the chair. Speakers shall not attempt to engage in debate with other meeting participants. Any questions?
No.
Seeing none, let us move to the first agenda item, the abatement appeal of George and Susan Brucia on their property at Davis Point Road, Cushing, tax map 29, lot 36. Anyone wishing to testify in this matter, please raise your right hand. Repeat after me. I'm presuming we've got. Garnett, are you going to
Yep.
be?
I'm the speaker, yeah.
Yeah, okay. I swear to tell the truth, the whole truth, and nothing but the truth.
I swear to tell the truth, the whole truth, and nothing but the truth.
Colin,
I swear to tell the truth, the whole truth, and nothing but the truth.
thank you very much. Anybody else planning on testifying? If not,
George Brucia may testify.
oh, this is, okay, George, yes, you are going to,
I'll probably be doing most of the speaking for us, but in case if you want to swear him in also.
yes,
I, George Brucia, swear to tell the truth, the whole truth, and nothing but the truth.
thank you very much. Okay, let us first confirm the ownership of the parcel. It is George and Susan Brucia. Is that correct?
Yes.
Yes.
Let us confirm the current assessed value of the property and the requested abatement amount. According to the application, the assessment of the land is $595,780. The assessment of improvements is $0. The total assessment is $595,780. Is the assessor's agent in agreement with these figures?
Sounds correct.
Thank you. According to the application, the owner's opinion of current value is land 450,000, building 0, total 450,000. The abatement requested is 145,780, which is a 24.5% difference. The appellants are citing that the assessment is manifestly wrong because the judgment of the assessors was irrational or so unreasonable in light of the circumstances that the property is substantially overvalued and an injustice results. Mr. Brucia, is this correct?
That's correct.
Yes.
Thank you very much. The tax year for which the abatement is requested is April 1st of what year?
2020. Right, Dad? The 2020.
Garnett Robinson, is
Yes,
that
it is.
you're approving? 4/1/20. Okay, and that is called fiscal year of what? 20 what?
Their calendar year.
Okay, fiscal year 2020.
Yep.
Okay. As you can tell, we have had all kinds of strange things happen with those. I would entertain a motion to stipulate the appellants have or do not have a standing in this matter of by virtue of their ownership of the property.
They have standing.
Okay, Jim moves. Anybody second?
Second.
Thank you. I presume we're moving have. All in favor? Seven in favor, which means none opposed. I would entertain a motion to stipulate the appellant's application to this board was or was not timely filed. Jim?
I'll make a motion that he does have standing, excuse me, that it was timely filed.
Thank you, Wes.
Second.
Jim? Okay, all in favor? 2, 3, 4, 5, 6, 7.
Can we have some discussion on that, Madam Chair?
Yes,
I don't see when the commitment date was for the town of Cushing or the denial date. The denial date, I guess,
that would be in the letter in the packet from the appellant.
okay. All right. So we've checked that. Thank you.
Okay, just to read that into the record, the date of the letter was November 12th of 2020. There is no indication of when it was received. And the appeal was received December 31st of 2020. So that's within the 60 days. The appellants may present their case.
Okay, so thank you. And I would just like to start off with, we believe that the board respectfully made a error in not allowing a reply to Mr. Robinson's May 6th letter. It was dated May 6th. It was
Which
postmarked
board
May.
would that be? I'm sorry.
Pardon?
Which board are you referring to?
Your board.
Our board.
Yes. Mr. Robinson's letter was dated May 6th. However, it was postmarked May 7th. And, you know, obviously it got to us well after the May 7th date. We received it Wednesday, May 12th. And, you know, typically in a situation like this, you know, the petitioners would have a chance to reply to an opposition paper. And I realize that this is not a formal court hearing, but nonetheless, in an administrative setting like this or in an agency setting, it would be best that we have an opportunity to reply. And so we would hope you will consider a lot of our arguments today. I'm going to probably try and discuss what we wanted to submit anyway, but just off the bat, because we only received it on May 12th, Maine state law says that, you know, when, I'm just going to quote it to you.
We know the law.
Okay. Well, it says when a party is served by mail, 3 days shall be added to the prescribed period, not excluding weekends. So, you know, if we received it Wednesday, Thursday, Friday, we sent an email to Wendy on Sunday night or Sunday afternoon. So it would have been timely for when you guys came to work on Monday. But that's neither here nor there. I just wanted to make that point. To the matter, so a taxpayer who seeks an abatement, you know, must establish that it was substantially overvalued. Supreme Court of Maine has said that a willing buyer, a market value, to determine the market value, a willing buyer, it's what a willing buyer would pay a willing seller at a fair public sale, and that a recent public sale of real property is evidence of market value. Now, Mr. Robinson has suggested that this was not a public sale, that we somehow had, you know, some benefit, that we got a discount or something. However, that's just not the case. I'm happy to provide you a link. I'm happy to share my screen. I don't know if that's necessary because it is readily verifiable, but the property that my father purchased was in fact listed. They were represented by an attorney, and the sellers were represented by a real estate agent and an attorney, and those papers, the closing documents, would reflect that a commission was paid. So they were represented by professionals. Mr. Robinson also suggests that somehow he spoke to the sellers and they were not aware of the value. You know, no affidavit was provided for that. That was hearsay. You know, in my opinion, that's hearsay, and it can't be considered. Supreme Court of Maine has a case, says where an assessor said he believed that the sale of the property was not quite a foreclosure, but in the range of foreclosures, but then provided no evidence on that point to support that the sale of a home was below market value. The court said that it was an error for that board in that case to consider that opinion. And so, you know, it's been established that this was a public sale. It's now on the assessor's. It's now the assessor's burden to show how it wasn't. And all he's put forth so far is that, oh, I talked to the seller. Well, that's just, you know, not. It's not clear, and it's not very good evidence, quite frankly. And when we're comparing the properties, you know, he makes a point that, you know, oh, it's the Talbot's house, and oh, it's the Brewster estate. Now, to be honest, I don't really know who those people are. I don't know that it matters. But we pulled the acreage and the land assessment for those properties. And the Brewster lot is assessed at $209,376 per acre. And the, excuse me here, the Talbot property is assessed at $176,493 per acre. Our property, and I shouldn't say our property, it's the appellant's property, is assessed at $263,619 per acre. So you can see that, you know, all these supposedly prestigious people that the assessor has cited are actually paying less taxes than the appellant. And as to the properties that were actually cited in the materials that your board received back in November or December, those are, again, waterfront properties. The Supreme Court has said that you know, neighborhoods of the same town need to be treated equally. And so with respect to, let's see here. The appellant in his submission to your board cited map 27 lot 28. Map 27 lot 28 is 52.68 acres. That's 23.3 times the size of this property. Nonetheless, it's assessed at $161,330 less than ours. That 52.68 acre property, by the way, is also a waterfront property with 1,088 feet of it in the water zone. That's this property has less than that. Mr. Robinson's assessment also doesn't consider the fact that we're in a when considering the topography, it's a high erosion zone. That should lower the assessment value as well. Our property is the only one of the only erosion zones on the Davis Point Peninsula. And then much is made, of course, about the CV Lane property. The CV Lane property, again, is larger than ours on the waterfront and is assessed at over $200,000 less than ours. I just think that that's clear evidence. Now, a lot is made about our view versus the view of the CV Lane property. I wonder if I can take a moment and share my screen here. I hope this works. You guys see that video that I pulled up? Can everybody see that?
I don't.
No,
What about now?
no.
I think Wendy has to enable screen sharing for participants.
Is that something we can do? It's only a 2-minute video, and then I believe my presentation will be just about done.
I think you can share a link also. I mean, if you had the link, you guys could click on it, maybe.
Yeah, then everybody has to watch it separately.
Well,
I just clicked on the multiple participants can share. Is that the right one, or do you want me to do advanced sharing options? I don't know which one.
When I hit share screen, what about now? How are we doing?
Okay, mine says,
there you go.
Yeah,
Okay.
now we can see it.
All right, somehow I made it through the whole pandemic without doing a Zoom conference, so bear with me. All right, so this is a video of the previous owner of the CV Lane property that was posted on YouTube about 2 or 3 years ago. Just so happens that it was the property that we're sharing, and so I'm going to play this. It's only 2 minutes long, and then I'm going to show you it comparatively with the heavily wooded area that the property at issue is dealing with. This property by comparison is much more developed, which
okay, so
includes
this
a
is
water
not your
line.
subject property?
this is not the subject property, but this is a comparison property that has been cited heavily. This is the property that is heavily compared to ours by both Mr. Robinson and us. So I don't know how this view is any better or worse than our view. And I'm going to show you some pictures of ours as well. You can see this is an improved lot in that it has underground improvements. Guys, I think my point is made here. So now, compared to, bear with me here. You guys can still see my screen or no? I exit out of this.
See your face.
Okay, thank you. Okay, this is our view by comparison. So I don't know, a lot is made of that our view is better or this, that, and the other thing. To me, that's purely subjective. And looking at these, it's nice. Obviously, it's nice, but it's waterfront property. But I don't see how you can say that this is worth $200,000 more a year in taxes, or excuse me, not in taxes, in assessed value. And you can see where that was a cleared field, low grass. This is all heavily wooded property. These photos, by the way, were taken basically right after we bought the property in the winter of 2020 or the spring of 2020. I got just one more for you, and you can see, that there's the water in the distance, but I don't understand how you're, it doesn't make sense to me to say that the other property is worse somehow than this property in value. And I just think that the photos and the video show that picture pretty clearly. The only other thing, and this is my George is going to probably have those details, but the amount of ocean footage is the CV Lane property is 300. Dad, would you know the figure for the Davis our property?
Mr. Robinson, the Cushing representative, Mr. Robinson, cited that with shore footage throughout his package that he sent, dated May 6th. And the shore footage, we probably have more shore footage, but we don't have the gentle slope to the shore. It's short cliffs all around. And if anyone were to go to the Cushing shorefront map, you'll get you'll see that our property is really probably 90% has a red line around it, which basically indicates a high erosion zone, where none of that exists necessarily in Cushing.
This is what he's talking about here.
That's the picture there. Okay. Now, you can see that further up Davis Cove, there's a little piece, and there's spotty erosion zones throughout the shorefront in the whole town, probably in the whole county. But that, again, as Colin had said wasn't addressed by Mr. Robinson, the Cushing representative, Mr. Robinson. It's no one denies that the property is nice property. It's just not as, it's equally as nice as a number of other properties which are assessed less.
I think we're just about done. The last thing I just want to hammer home is that Mr. Robinson is saying that it was not an arm's length transaction. Now, we have provided evidence that it was, and that there are public records that say that it was, and he has not come forth with anything other than to say he said, she said, that they didn't know the assessed value. I mean, they were represented by professionals. This was posted online. I wonder, just to really quickly, yeah, here we are. Here's the public. Here's the link. Lot 36. That's us, and you can see. You can see that it was sold at $450,000. Listing office, selling office. The sellers hired professionals to do this, knowledgeable local professionals. And we're from New York, where we're not buddies with anybody up there. That we're gonna get some deal on some land, and so it's very easily verifiable that this was a public sale. And when it's a public sale, the Maine Supreme Court has said that that's evidence of the market value, and market value is an indicator of assessed value. Unless there's something else I missed, Dad, you want to add? I think I can yield the rest of my time.
Your time is just about up, so make it short, please.
Yes, ma'am. I will add that the previous owners were brother and sister, and they inherited it from their father, who inherited it from his mother. So they had a long standing, which would further support the idea they had full knowledge of the area, even though they lived far away.
Okay.
And that's, if I forgot something, we'll deal with it.
You'll have another opportunity.
Exactly. Thank you.
All right, thank you.
Thank you. Does the board have any questions for this appellant? I see none. Okay, does the assessor have any questions for the appellant at this time?
I don't.
Thank you very much. The board will now hear the presentation of the assessor from Cushing, Mr. Robinson.
I think for ease, I'm just going to read in my statement to your board and then address just a few points that I'd heard there. So.
Okay. Oh, I'm sorry. Before you start, your state ratio for the assessments in Cushing for tax year April 1st, 2020.
I don't have it in front of me. I think we're certifying over 100, but I don't, and we're not there now. So we've had quite a change.
May I interrupt a second? I apologize, but I would request that Mrs. Robinson advise Mrs. Wendy Galvin to forward that package that we emailed last Sunday night to all the board members at this time, so that they can look at that and have that on their computers.
Was it only forwarded? Was it only forwarded to me? I didn't. I mean, I assumed.
No,
it
I
went
forwarded
to
it
the board.
to you, but can I call you Garnett instead of Robinson?
Yeah, absolutely.
Robinson? Thank you. You call me George, all right? I forwarded it to you as a matter of courtesy and procedure. And I sent it to Wendy Galvin as well, and I took a pot shot at trying to send it to the board members on the knoxcounty.gov website, but they don't have one. When Wendy on Monday morning contacted Mrs. Robinson, she said, no, I'm sorry, it's too late. It can't be forwarded to the board. So I would respectfully request that Wendy do that at this point, so the board has it on their computers and can refer to it again during their deliberations. That's our written statement and the videos and the photographs.
It was a lot of what we just went through, and then I would also add, so to the extent that, you know, you have a video and and to the extent that you have a record of this meeting, I, did the screen share and I showed you what we did. It would be helpful, I think, for you to have our statement, but I've already addressed that at the top of the meeting, as far as my complaints about the procedural issues.
Okay,
But thank you.
So it's in the,
Can I just make a point for the
Yeah,
board?
Garnett.
I think my understanding is that the board, you get your appeal notice from them. We have to answer, we're given dates, and that they have access to what we're going to be testifying to, and that's what we're doing. So I have no problem with his, I don't think there's anything that was, dramatically different than what he had in his original filing. So I don't have any, normally if I was a lawyer, I guess they'd be saying, no, but I don't care if it's 7 pictures and I guess another statement, basically, and if you want, I can read that in for him. I don't think it changes anything.
Yeah, and it was essentially just a
Mr.
rebuttal.
Brucia, Mr. Garnett Robinson is testifying.
Apologies.
You will have an opportunity to ask him a question later.
I can, I'm going to read in what our answer was, just so that it goes before your board, just reiterate, because it goes to the sections. We use front foot pricing, not acreage. I mean, if you did if you did the simple division on any number of lots, if we have a half-acre lot that has a developed parcel with, a large value, it might even have a much higher per acre cost if you went and did that simple division. It doesn't work like that when you're using front foot and depth. So we, basically the town is using front foot and depth. His lot, if you saw the listing they just showed, it says 600 front feet. We use, so if you look at where we actually used, and you go to his, I guess it would be exhibit. Pelham's deed, Pelham's map lot. Davis Point portion for 29. I have his valuation report from Trio in there anyways. We use what we call effective front feet. We didn't use all of his front footage. If it's not straight line, we use a portion of that, and we adjusted for it being on a point. I guess the big points for making here when they were talking about the other property that was on CV Lane, I think that is a good comparable for them to use, for them to look at, and for you to consider. But you will notice that what they have for frontage is much less. They also have a right of way where it allows other properties to cross to the water, so they don't have the privacy that you would have from most waterfront lots. You have people that are off water allowed to cross that. Where they're being built is open. It's already had a house originally and it was tore down. There was an old garage there, and for us, we'd gone through studies. We have actually 2 different values for front feet, based on front feet if it's developed with the highest and best use, which is in Cushing would be a house or a seasonal or full-time residential residence on the waterfront. And so in this case, they tore that down. We didn't add for the well, septic, and driveway. We do those separate. That goes as a site add. We didn't add, and that was basically because of code enforcement and the owner at the time had told us they were questionable. They didn't have it on file about the septic. So I didn't add for that, but that's only 13,500. So just briefly, I want to read in just what we had written there, because that is my entire argument. So I'm writing in response to the property tax appeal now before your board for George and Susan Brucia's property on Davis Point, appearing on town tax maps as map 29, lot 36. The Cushing Board of Assessors met November 5th, 2020, and voted unanimously to deny the Brucia's abatement request. It will answer charges directed to your board in the appellant's November 24th, 2020 letter. Davis Point's protected in property and ability to trespass. Exhibit 7 is the tax map showing the Davis Point area with the appellant's lot highlighted in pink. You will note that it's on a point. Please note, area in yellow is being permanently protected open space with protective easements. That is the Davis Points Woods and Waters that we refer to, and if you'll see it in the deeds. All other lots on the point are developed, with the Brucias being the last developable parcel in one of the premier neighborhoods of Cushing that has been the summer home of the Talbots, the Talbot store fame, the Brewster estate, and other famous residents over the years. Their lot is situated in a corner of Davis Point and has for Cushing an exceedingly rare and desirable unobstructed water view. I think it is similar to what you would have over in CV. The value derived from the protected nature of Davis Point does not come with the ability to walk on the neighboring parcels, but that the point will not change barring disaster. If you look at this, the entire Davis Point, with the exception of their lot, is developed and surrounded by protected land. Comparison to 15 CV Lane. Note Exhibit 10, the CV Lane property card under notes has a note to check in 2021 that on May 28, 2020 inspection that repairs to the dilapidated garage have been started but estimated as occurring after April 1st, our tax situs and status. There was also a note in 2019 that the property had been changed to undeveloped due to the unknown state of the well septic per code enforcement. And then I would reiterate, it didn't have a house any longer. The garage was questionable. With the house being torn down in 2013 and the garage in such a bad state of disrepair that it might only contribute value for permitting. Page 2 of the property card is a picture of the garage from May 28th inspection, showing a new slab, improvements, etc. Also in Exhibit 10 is a copy of the valuation report, and please note that the property is assessed with 270 effective front feet. The town values waterfront on a front foot basis, and that price per front foot starts at $1518.75 for both neighborhoods, I should point out, which if you look at Brucia's valuation report is the same, except it has 390 front feet. Remember I said about effective front feet? They have 600 feet actual on there. We're only assessing 390 feet of it, and has an upward adjustment that we apply to point lots in town. You also will note that 15 CV Lane is reduced by 5% for having a right of way across to the water for non-waterfront owners that is not on a point, has less viable river and Gay Island views, and is not as protected in a protected neighborhood, and is surrounded by new buildings going up, etc. The tax map for map 30, lot 15, has 15 CV Lane highlighted, showing the 20-foot right of way and non-point nature of the lot. So if you look at it, you can see it's just a flat lot, a straight lot with properties on each side. Actually, in that listing that they're showing there, when they pan to the right, to the left at the bottom, it shows the roof line for the neighboring property. And that's part of what's desirable for point lots, is that you don't have your neighbors to obstruct your views or to look at your neighbors. Per the Brucia's note, there is a property owned by George's River Land Trust, is perhaps a mile to the trailhead from 15 CV Lane, and it is protected, but it does not protect the nature of Stones Point for future development, and is in fact open to all people, not just Cushing residents. This is owned by George's River Land Trust. So it really attracts people rather than makes it more, I would say, exclusive. The Brucia's final note about the open nature of CV lot is very true, but they do not note that now with new development on both sides, that 15 CV Lane has perfect views of the neighbors' houses and vice versa with little privacy, and is one of the reasons point lots usually sell for more, because of the ability to have screen views. Brucia's number 3, the Brucia's reference to the estate sale nature of the property is not the only reason that the sale was not considered arm's length or reflective of market value. I haven't talked with one of the previous owners. I am now under a sworn oath. I did talk to the previous owner. In the past, prior to being sold, found that they had not seen this property and were unaware of its value. Market value requires informed decisions and no undue influence. An informed an owner of inherited property in a protective trust, not from the area, is not likely to know what an informed seller would know, and which would be that the rarity of lots such as theirs in Cushing demand higher prices than lots of similar size in different parts of town. Please note that the Brucia's listed large number of lots, both developed and undeveloped throughout Cushing, with differing orientations for your consideration. I just note in here, I started to go through the exercise of making those copies for you of these cards, just to show you, so you'd have them available. I did review the cards, you know, I mean, I think a part of what he's tried to submit later was that we didn't consider his information. We did consider his information. I don't think land and building sales are relevant to this. I don't think title upriver sales are necessarily relevant either. There's a number, you know, like I do think 15 CV Lane that they provided you is a good comparison. They did not add data, so like we're not comparable. And as the Brucias did not add data beyond acreage in the land valuation, me adding this information about them would probably confuse the issue. I did, for the board's benefit, add Exhibit 8 for the non-point Brewster lot, which you will note is valued at a higher beginning lot value. We have developed lot prices, front foot prices that are higher for developed lots. That came from our sales studies. We actually did residuals, and land and building properties sold at a higher rate than undeveloped lots. Developed lot sales required higher prices per front foot than undeveloped ones, even beyond the site ad. Reduced by 15% for having right of ways across it, and having deed restrictions applied when subdivided from the Brewster estate. This lot they can only build in a small window of that lot. Along with Exhibit 9 for the Coronis Lot 37, which also starts out at 2,025 per front foot. That's in their list. And you'll note it is adjusted by the same 25% as theirs. It's only 170 front feet, so it's a really small lot. Exhibit 6 is Brucia's deed. I just added that. In their letter to you, they were describing having problems with the right-of-way. Their deed had a right-of-way, and it was never brought up to our board that there was any access issues. To synopsize, the board's denial of the Brucia's abatement request came from review inspection of the appellant's lot, tax maps, budding parcels, 15 CV Lane, deeds, property cards, notes, valuation reports, and determined that the Brucia parcel was assessed equitably according to its just value. And so I'm not going to read through all those. You all know all of that. I do have your exhibits when he talks. I have the Constitution. I have Title 36, 701A. I talk about burden of proof, has the credible evidence requirements. I do have a definition of market value. I do have a list, a definition of arm's length. Let me see if there's anything else that he's added that I should talk about. I talked about developed versus undeveloped. I talked about using front feet. We use not just linear front feet, but we use effective front feet. So that's the difference between his 600 and the 390. We did the same for the other one over on CV Lane. I think that's it.
Very good. Thank you very much. Are there any questions from the board for the assessor?
I have several.
Okay. Tom, is that you?
Wesley. It's
Oh,
Wes.
there you are. Okay.
Okay.
Sorry about
Some simple ones to begin with, but can you confirm that Exhibit 10 is a portion of Map 30?
Okay, yep. I'm sorry, they don't give me a really good printer in there, so I can only get portions at a time. So Exhibit 10. It is. And it's identifying, the highlighted portion is identifying 15 CV Lane.
Any other questions, Wes?
On Exhibit 7, I guess on the right-hand side, it says Davis is the eastern side of the property, I will say. Is that facing a cove, a river, open ocean?
It's facing the open ocean. If you're looking at it from, if you turn that so you're facing the letters at the bottom, that's basically facing straight out towards the ocean.
I don't want to mess up, at least you're in.
And like, do you happen to know whether the Campbell property was in probate? For how long it was before it was listed, or how long before it was sold?
I don't have that in front of me. It was in probate. I don't know if it was in probate, but it was an estate.
We good? Wes, do you have
We're
any
good.
further comments?
No.
Okay, any other further questions from the board?
I have a question.
Okay,
Mr. Robinson, do you use the same process for all waterfront lots in Cushing?
We do. We have a few neighborhoods, I would say. There's, I mean, if this was title way up in the river, it would be a different front foot price, but it was use the same methodology.
Okay, so the same methodology is applied to all lots in a
Throughout
given
town.
neighborhood, same
Yep.
methodology. And you maintain, I think you confirmed that you do not consider this an arm's length sale,
I do not.
and this is not included in any of your cost studies.
No, we're in the future, we're going to be looking at sales again, and I probably wouldn't use this one either. So, I
Okay,
mean, right now we're at a point like last year versus this year, we've had a real change, a dramatic change in market value, which I think anybody working in assessing will see is we've had a lot of properties that have sold for more this year than they were last year. This is based last year. We hadn't made any adjustments. We hadn't done, we hadn't adjusted for any neighborhoods. We hadn't done any major sales studies at that point. So.
okay. Has the budget for Cushing changed that much? In other words, the mill rate, has it changed?
It's changed quite a bit, and I mean, where it says Pataboot, that's actually Billaboot. He's the chair of the board. He might be able to talk more about increased costs, but our school budgets and a number of other things have increased dramatically. Our mill rate historically has been 12 or below, and in the last 3 years, it's gone up significantly.
Did you supply us with any historical assessments on the subject property? I didn't see any
I did not.
on the property card.
I was using the valuation report because I wanted you to be able to see the front foot prices.
Okay. That's all the questions I have, Madam Chair.
thank you, Tom. I have one question for Garnett. Are sales from 2016 used by Maine Revenue Services Property Tax Division in the current sales study to develop evidence of the current tax year's real estate market in Cushing?
If we're looking at a current, I mean, they use last year's, typically it's last year's for next year's valuation. They've extended usually 6 months and 6 months.
Okay, so then 2016.
They wouldn't be looking at that one probably now. So I mean,
okay,
they go
so
back
then-
whatever they need to have sales, and we have enough sales in Cushing to be able to do their sales studies. The main revenue when they're looking at it is, as you well know, or some of you may not know, is that they use land and building sales. The land only sales are just for them to develop their excess rates, but
Okay, very good. Any further questions for Mr. Robbins? Yes.
So in assessing the CV Lane property, you said that there were buildings built after the fact, right?
yeah, if you go down there right now, that's part of what we did with Spring Review is there's new houses on both sides. There's actually a house when you look at your video, when you show it down at the bend there and looking off to the left, that's a house that was already there. There's now new ones on both sides.
But that assessed value came before the new construction.
Absolutely.
So how is that relevant to the current, the current comparison?
I guess the great comparison would be is that can't happen to your property. You're on a point, it's protected. You're not going to have properties on both sides of yours where you're looking at the neighbors. It's impossible.
So I would just like to point out though, that the Coronis property, your exhibit 9,
Mhm.
that's not a current picture of the Coronis property. When you're standing on the lot, you can very easily see both the neighboring properties. And in fact, I understand the value of the view, but because of the shoreland zone requirements, you're not gonna be able to build up on top of the point. So, you know, you're gonna, if and when we build, we're gonna be building back. And, you know, the neighbors we can wave to the neighbors still. The Coronis property has a substantial improvements done. They've got multiple stories. The picture in that card, that's exhibit 9, I believe, is like a small little cottage. That's not.
Yeah, he's got a big house that's built back. I do realize that.
So I'm just, I guess, confused about the comparison because, you know, we have neighbors that we can see too. I take your point that they have a right of way, certainly, but, you know, obviously, unfortunately, there's not another Davis Point Road to directly compare. And then I would just add, I know you said that you looked at the other properties listed. The 52-acre lot, though, why was that not considered as a comparison?
A 52 acre to your lot there is no comparison, and it's not I mean, if you're looking at comps, if I do use that as an appraiser, I'd be drummed out. I'd be for the appraiser board for using a 52 acre board to compare to yours.
Well, it's
the burden of proof. I'm sorry, Mr. Brucia, is that you show us, your materials. I would offer to go over any of this at any time with your father or you or your mother. I met with your father and mother when they were looking at buying, purchasing. We met them well ahead of time when they came in to introduce themselves and saying they were looking at purchasing. So anybody would have access to any of those. So a 52 acre lot, and you divide it out by acreage, it's probably going to be minuscule, but it also, there's a big difference is that 52 acres have 100 front feet and the rest of that is rear acreage. I didn't see it as being relevant. So I didn't spend a lot of time saying, what would the comparison be to a lot way upriver to this one in Davis Point. When we talk about Davis Point, and the longer you live there, you're going to find out that Davis Point, Stones Point, Birds Point, any place that has a point behind the name is where our highest values are. And we're starting at the same front foot price on those both, so when you're looking at Stones Point and Davis Point, if I had my choice between lots of any lot in town, you probably have the best spot for an undeveloped lot, because nothing that happens when you build is ever going to be different in that neighborhood. You drive out there and there's a field that's just spectacular. Go ahead, Jim.
I know, I've been there. I just, if it riverfront, whatever, I just, that's a big property to be assessed so much less than ours. That's really the point that we're driving home. And it's not in the backwoods, it's also on the water. I know you made the distinction that it's up river, right? It's still a waterfront property. And then I would just
getting repetitious. Do you have anything that's new?
Yes, thank you. I'm just, asking a couple of clarifications. Thank you. But you just talked about the burden of proof, Garnet. Our proof is met because there was a public sale, and you're saying that, oh, I spoke to such and such, and I'm not saying that you didn't. It's just there's no, that's not verifiable. That's not there's no evidence of that. That's all I would say about that. And the Davis Point Lane Association, we're not a member of that. I read your letter, and I not 100% sure what you were saying, but I think what you were saying is that membership in the Woods and Meadows Association is valuable. Is that right?
No. What I was saying was an answer to your father's letter of grievance, and also what he wrote to the board, which is basically saying that yes, there's private property that surrounds us. He's saying protected property, but we're not allowed to walk on it. My point is that this is permanently protected land. It's in It's in a conservation trust. It cannot be developed. It'll never be developed. Whether you can walk on it or not, that's not the reason that adds value to your property. It's not. So if you look at Georges River Land Trust, the one you used as a comparison, saying you could walk easily. Well, it is an easy walk. It's maybe a mile from that property on 15 CV Lane. That is open to the public. It's Georges River Land Trust. They have a parking area. It takes away from the exclusivity of the area. It brings people in from other towns. Anybody can go on that property and walk it. If you go to Davis Point, it is only people that live out on Davis Point that have apparently joined the Davis Point Woods and Waters Association. They paid a significant amount to buy that property at one point.
Sure.
So that's the reason.
So, but as a non-member, how does that add value to my property?
It's permanently protecting surrounding area from being developed. You have, if you drive in that field, as you come into your property, all of the lots that are on Davis Point are developed right now. There's not anything that's going to be added to that property other than your house. If yours gets developed, that's the only area left on Davis Point that can be developed.
Okay, thank you.
May I ask a couple of questions too?
Where are we? If they're not repetitious, all of this
No, they-
latter stuff is, we would like
Okay,
to get to the deliberation.
Okay. What Mr. Garnett, what Garnett discusses is in his letter about a dilapidated garage has
The
been.
dilapidated garage is not on your property and it's not a subject of your assessment.
No, I understand that, but that's what was in the picture, was the piece of the garage. The garage has been renovated and there is a house now built on 15 CV Lane.
That is not being considered as part of the assessment of your property.
Okay. Is regarding this, Garnett's discussion about view of the neighbors, it's a heavily wooded lot. We have to create a driveway. We have to create a clearing to build a house. And then both neighbors will be clearly visible. Both of the neighbors' houses will be clearly visible. By the
There
way,
will be an expense to that, and that'll be added as making your lot a developed parcel. Your lot is
additionally,
not a developed parcel, and we cannot consider the fact that the development costs have anything to do with your current assessment.
but he talked about the idea that it was more valuable because you could not see the neighbors. And I'm saying that you can see the neighbors clearly right now, and it'll even be more clearly down the road. If I turn your attention a minute to exhibit number 7 from Mr. Garnett's May 6th communication, you'll see a map, a tax map or a lot map of the area. And if you go down, you see at the bottom, our lot is highlighted. And then you go up and you make a right and a short left, and then go up and then make a left. Right at that point where you make the left, all the way down through our lot to the right of Davis Point Road is a right-of-way. So a right-of-way also goes through our lot. It's not used, it's grown over, because Davis Point Road is the road that the people use. But there is a right-of-way. There's mailboxes up at the furthest north point that I referred to. The right-of-way parallels the road. It turns where there's the short turn, the right and the short left, and it parallels, it comes right down through to the shore. So we also have a right-of-way. That right-of-way is not used. After we purchased the property, the Davis Point Woods and Meadows Association created a new right-of-way just to the north of the northernmost point of the Coronas property, which is lot 37, and came in off Davis Point Road and then picked up that existing right-of-way to bring so that our property was no longer landlocked. I wanted to make that perfectly clear. And finally, Mr. Robinson talked about the value of prices. Yes, the value of prices everywhere. I'm sure those Park Avenue apartments don't get anywhere near what they got in 2019. However, we made a deal for the price of the property before the pandemic. So what has happened to the prices in 2020 with everybody trying to move to more rural or suburban areas to avoid the tragedy of this pandemic is not really relevant to the article, but, you know, the point is that in the late fall of 19, in November to be specific, is when we reached an agreement on the sale of this house, not during 2020. And
Thank you very much.
that's probably all I have, I think.
Thank you. Anybody like to move to go to the, close the testimony phase and move to the deliberation phase? Jim? So moved. Second, Martin? Thank you. All in favor? 2, 3, 4, 5, 6. We lost Tammy, didn't we? Okay, thank you. The testimony phase of this hearing is now closed. The board will now move to the deliberation phase of the hearing. There will be an approximately 3-minute break while those who wish to listen to the deliberation log on to the site. There will be no more testimony taken on this issue, but you're welcome to stay and listen to the deliberation if you wish. But you may not participate if you are not on the board. Thank you very much for your testimony, and I appreciate all of your work.
Will Wendy be sending a link?
Yes,
And a telephone number too, please, okay?
I'm sorry, but we can also stay on this Zoom call and to listen in, or is this
you're
ending?
going to be cut off of the Zoom call because
Oh.
we're going to be deliberating,
Okay, thank you.
but you can listen in.
Gotcha.
The
Thank you
link
very
that
much.
she's going to send you.
Thank you.
Thanks.
Hello?
Successful based on the body language of the people. And that but it's not upriver.
Someone should tell Mr. Brucia he's on live mic.
Aren't we disconnecting non-board members?
Yes,
There.
See, how do I do this?
Foot fell asleep.
Do you need me to disconnect anybody that's not a board member?
yes, please.
Okay, hold on.
I have one block that is still connected.
Okay, it looks like everybody except for the board members is off of the call.
Thank you very much.
You're welcome.
Okay, we're in the deliberation phase. Anybody have any deliberations they'd like to make? Anybody have any findings of fact they would like to set forward? We already have two, the one about the standing and the one about the timely filed. I am looking for a third one. Jim,
I'll start with just some thoughts I wrote down prior to and then have adjusted since hearing the testimony. In peeling back all of the information that was presented about price per acre, price per square foot, or not per square foot, per acre, per front foot, views, access, right-of-ways, all of that information has no bearing. Nothing was presented that said a property gets more or less value because of a certain circumstance. It may be all true on the subject property, but the only data point that I've hooked on to is the assessed value and the purchase price. There's a lot of contentions, but nothing showed me that how those things matter to the value. And when in checking over turf loss, since it was brought up by Colin in his presentation, it was on his screen. The law court said, although we have not held and do not hold today, that the price of an arm's length sale is dispositive of a property's fair market value. The board's factual error regarding the arm's length nature of the purchase caused it to give too little weight at the sale price. We've heard testimony that it was an arm's length transaction and that it was listed. It was listed and was an arm's length transaction. Again, there's nothing, I didn't find anything in all of this that I could say it's undervalued or overvalued, other than just the sale price, which is somewhat questionable. There was an adjustment made to the property of a plus 25% because it's on a point, and the town testified we do that everywhere, but there wasn't any evidence to support that particular contention. And there's a recent law court case of Rogue Island Gardner Homestead Corporation versus Jonesport, where the town upcharged the building values 100%, and that was contested by the applicant and brought credible evidence enough to the law court to say there was credible evidence that that was an overvaluation. But we don't even have that here, that we have any information other than the sale price and the assessed value. Collins spoke to price per acre, but USM has made that very clear that how the value is built is immaterial as long as it's just value. So I just found not a lot to hang my hat on. I don't know what anybody else thought, but I just, one way or the other, the town didn't support its value, and the applicant, other than the sale price, said that's the market value. But the law court was, pretty clear that they just don't take a purchase price as just value. That's sale price, not value. So
that's what is paid, not what the value is.
Right. So I'm not discounting the applicant's contention, but just seems so little to work with.
Well, that was why I asked the question about the sale being in 2016, and was that in the collection of sales values that they used to develop their rates of assessment in Cushing? And he said, no, it wasn't. So I don't see that sale price having any basis for determining the valuation in this fiscal year.
Madam Chair,
Yes,
I have a couple of observations. Number one, assessments cannot chase sales. So just because a property, even if it's an arm's length sale, the assessment for that single property is not usually changed. And the case law says that equity trumps value. So if there's a contention between value and equity, equity wins out. And however value is determined here, if the process is the same across all properties in defined neighborhoods, then to me that says it all.
yes. Okay, so can we make some findings out of this? Did the appellants prove that the assessment is manifestly wrong?
Is that a question or a motion?
It's a question.
Yeah, I don't believe they did. I agree with Jim, frankly, that it's, I thought both presentations were wandering down a meandering path. And as a board, we've never reacted to a purchase price setting the assessed value. And everything that I've heard quoted for case laws has been not supporting a sale price. So I don't believe their contention, which is primarily hung on the purchase price, is valid.
Okay, this is taken pretty much from the potential findings of fact that I shared with you.
Mm-hmm.
Number 10, the burden is on the appellants to prove that the assessment is manifestly wrong. Citing Newsom v. Raymond. Anybody like to move that as a finding?
So moved.
Thank you. Second?
I'll second it.
Okay, anybody see anything else that they would like to point out as being something that they think?
Well, number 3, the potential findings.
Okay. Where the assessor showed that other properties were assessed by the same schedules. And the reason for the difference was developed and not developed. So they have not shown that the property was assessed differently from other properties in the neighborhood, citing McCulloch. Anybody? Okay, is that a motion? Jim? Your call is up.
I'll leave it to Wes.
I'll make the motion
Thank you, Wes.
that they have not met.
Jim?
I'll second that with the comment that neither the applicant, if the applicant or the town has shown us anything about the extra adjustment through a paired sales analysis or something, I would end up in a, perhaps in a different place. But there's, I agree with Martin. It's just there's nothing to grab a hold of here.
Do we want to make a statement about that, or
Just make a statement.
grab a hold of?
Mm-hmm.
Pardon?
I don't think that's a legal phrase, but that's okay.
Okay. Okay, I now have 4 findings of fact. Okay, about number 4, the appellants show only the price for which they bought the property in 2016 to determine the value of their property for tax year 2021. That's, well, tax year 2020, sorry. this is adequate or not adequate to meet their burden of demonstrating that the assessment is manifestly wrong. Anybody interested in that one? I'm not seeing any interest.
Not, I would say not adequate. And I would make that a motion.
Thank you.
I'll second that.
That was Martin.
Yes.
If I'm not watching the screen, I don't see the lips move. Sorry about that. Do we want to delve into whether or not it was an arm's length sale?
Yes.
Okay,
I think it was arm's length mostly. The deed document did say heirs and successors of the trust. I don't know if heirs was, in the typical sense, a real heir of a property, or if they were just also the successor trustees, which would also be, that would be okay. That would be fine. There's a little bit of information. I would have liked to have known how long the property was listed. In Turfloff, the argument was it was listed for 3 years and there was a history of price reductions. We don't have anything like that here. No, it just, like as I mentioned earlier, there's just
nothing.
not a lot to hang on to.
Mhm.
Okay, so, okay, you want to say the purchase of the subject property was an arm's length sale. You want to refer then to the remainder of that potential finding of fact as whether or not that should be used as a base of determination of the current assessment?
If we're still in discussion, I would disagree with that.
Okay.
I think ipso facto, any sale that is an estate sale can legitimately be thrown out of consideration for a cost study.
Doesn't the
Well-
state do that?
Well,
No,
it-
Lauren.
so the deed, I mean, I didn't think that it was worth asking the parties because I just don't think they have the authority to testify about it, but it says it's a deed of trustee and it doesn't say anything about an estate. And it's strange to put heirs and successor trustees. And then also, if you look at the one recorded at page 16, it says the Anna A. Campbell 1998 trust, and the other page 17 said Anne A. Campbell. So it just looked like there were all kinds of typos on this, and I don't know who prepared it, but perhaps it was not prepared correctly, but it certainly seems like it's a trust deed and has nothing to do with an estate. That's what it looks like.
That's a good point.
I don't disagree with that.
Because I would never write, if I'm drafting a trustee deed, I would never say as heirs. I mean, you're a beneficiary of a trust, you're not an heir of a trust. So I don't know what that meant.
Personally, I don't see how we can consider this arm's length or not.
Yeah.
Okay, so if we forget about the arm's length part, the deed is a trust deed, not,
Not like a PR deed of sale.
Mhm.
It said heirs on it, but I agree. It's
Yeah.
just, I don't know. It's almost like they were trying to do too much with one deed.
And the reference paragraph in the exhibit A didn't give a clear trail of where it came from exactly. So I really think you'd need to see the title, and I think that's beyond our scope.
We are not in the title business.
I am, but not right now.
Pardon my ignorance, but what is PR?
Personal representative.
Okay. Because I know Wendy's going to ask me.
Well, concerning number 6,
Okay,
instead of was not, could we put something in the purchase of the subject property? Or let me see. The testimony and evidence presented did not give us a clear understanding whether the property was an arm's length sale or not.
Mhm.
okay.
Don't ask me to repeat it, but
Let me write it real quick.
Yeah. I don't disagree with Tom. Just don't know.
Yeah,
Just the whole case was like that for me. I just
Uh-huh.
didn't.
yeah. And the
Well,
burden is on the taxpayer, so.
Yeah.
Exactly. Okay, testimony does not give the board a clear evidence of whether or not the sale is arm's length. Is that
Or not.
what you said?
Yeah. Or not arm's length.
Okay,
Is or is not arm's length.
all righty. So you want to move that, and anybody like to second that?
Second.
Martin, thank you. Okay, so what are we gonna do about the first part, the purchase of the subject property was or was not an arm's length sale? Get rid of that, right?
I would suggest ditching all of 6 for what I said.
For what you said, gotcha. Because we have no idea what in the world they meant. Okay. So we have so far, the appellants have not shown that their property was assessed differently from other properties in the neighborhood. The appellants show only the price for which they bought the property in 2016 to determine the value of their property for the tax year 2020. This is not adequate to meet their burden of demonstrating that the assessment is manifestly wrong. The testimony does not give the board a clear evidence of whether or not the sale is arm's length. The deed is a trust deed, not a personal representative deed of sale. What else have we got?
I just have one question about that. You said something about 2016, but didn't they get it in 2020? Did I understand that correctly?
No,
I
the sale was in 2016.
Yeah.
I thought they bought it in 2020.
The deed
2020.
is, yeah,
Yeah.
Right. They bought the property in 2020.
Where did I get the 2016?
I don't know.
Ah. Okay. I need to change number 4, 2020. If they bought it in 2020.
Right.
What was the date? I'm sorry. Got too many pieces of paper.
February 24th, 2020, and recorded on the 25th.
Okay, what was the month of purchase?
February.
February 24th, 2020.
February, okay, so it's before April 1st. That's what I'm. trying
Right,
to-
and recorded on the 25th.
It's legitimate for the tax year. Okay. Beautiful, thank you very much. Okay, looking down. Number 7, anything there that anybody's interested in? Anybody interested in any part of number 7? Not seeing any interest.
No.
Okay, 8. I don't think we had an assessment ratio there. He said it was over, he was declaring over 100%, but
He didn't have the figure.
he shied
Yeah,
right
figure.
away from that,
Yeah.
which is why I did not go to the quality rating.
Mhm.
That, I'm
So
hearing a
that's
female
9 then?
voice. Know who that is? Okay, the appellant's assertion there can be another value for the property does or does not defeat the assessment. Use them, number 9.
The only other value presented was the sale price
Yeah. Well, and the assessment,
and the assessment.
yeah.
Mhm.
They
Don't
asserted
necess-
that there can be another value for the property, which is the sale price. But they did not prove that it is more correct.
I don't disagree with the applicant, but I don't see where they showed the town's value to be incorrect either, other
Right.
than just the purchase price.
Well, that being the point, they, you
That's-
know,
you know,
just showing another value doesn't prove that the assessment is manifestly wrong. It goes to not winning a point.
right.
Correct.
Okay, you want to use 9 or not?
Does not.
Does not agree.
Does not.
I'll motion that.
I'll second that.
Thank you. Okay, we've already got number 10. The information provided by the town shows the Brucia's property is or is not assessed as similarly situated parcels.
The assessor's agent stated that.
Well, he showed the other parcels that are assessed like the subject.
That are on points.
Mhm.
That are on points.
Okay, so anybody want to jump in on 11?
I'll
Say it
motion.
is.
Yeah, I'll motion that the information provided by the town shows that the Brucia's property is assessed similarly situated parcels.
And I'll second that.
That was Wes?
Yes.
Didn't look up quick enough, sorry. Okay, we're rolling into the final. The appellant has met or failed to meet the burden of proof that the assessment was fraudulent, dishonest, or illegal.
None of the above. I don't think that's the argument here.
Okay, skip 12. Appellants have or have not proven the just value of the subject property is more than 10% different from the assessment of the subject fiscal year.
Same thing.
Well, I do think they did show that, but there was no other value other than the purchase price.
Okay, they didn't show us a just value is what they didn't, right?
Correct.
Okay, skip 13.
Yep, that's true.
Okay, 14, the appellants have or have not proven the denial of the abatement request is manifestly wrong.
I'll motion have not.
I will second.
That was Martin.
Yes.
Okay. Therefore, it's final decision based upon findings of
Madam
fact.
Chairman,
is for the- Yeah.
excuse me. I don't think it should be worded as the denial of the abatement is manifestly wrong. The law says the assessment is manifestly wrong.
Okay,
Yeah.
have not proven, okay, the deny, well, what they're doing is, what they're appealing to us is the denial of the abatement request to the town.
I would strike, going down Tom's thought, I would strike denial of the abatement request.
Mhm.
So we would read, the applicants have not proven that the assessment is manifestly wrong.
That's
Good
what I
catch,
would,
Tom. Yeah,
that's what I would say, Jim.
good catch.
Got it? Okay, very good. You want to vote on all those?
Yes,
Everybody know what we're voting on?
Yes.
yes,
Anybody need to have them reread?
no,
Love it. Okay. All in favor? 1, 2, 3, 4, 5, 6. Yes.
What happened to Tammy?
She was having connection problems and she blew out in the middle and tried to get back, but she couldn't.
I think we ought to
So-
just,
Hmm?
one comment on that, just make note, maybe in our minutes that that's occurred.
Yeah.
That she started, but then.
And so did not vote.
Right.
Okay, so the final decision is for the town. This portion of the meeting is complete. Thank you to the appellant and the town for participating. The board will next be discussing a matter of housekeeping. We have Tom has graciously presented the abatement event chronology paper that you were all emailed. This is used by the town of Rockport. Is this something that you can see us perhaps using, either for our own uses or for to give to the appellants to make sure that they've got all that? I mean, we're about halfway down the list before they get to us. But it would be nice to have those dates filled in. Obviously, there are two dates on the yellow portions that are filled in that would have to be deleted, but
Would
I
it
think
be,
it's a good roadmap.
yeah, would it be appropriate to put this as part of the package?
that's what I'm
For the-
thinking.
Yeah, for the town to complete, at least the part of it?
Yeah, so that at least we would have some clue and they would have to, if they didn't know it, would have to ask the town.
Right.
Okay, part of package. The third item from the bottom, the date. Their 30 days starts from their receipt of the denial by the Board of Assessment Review, not from the denial by the
Right.
board. So either that needs to be two different things, or there needs to be the denial and then the date of the receipt. Because the date of the receipt starts their 30 days.
Right. We've had some trouble with the 60-day window as to who got what, when, and where.
Mm.
It would be nice if that was cleaned up a little bit and documented. I will say not cleaned up, but documented.
Well, yes, the green cards need to be used,
Right,
and there are towns that are not using them
right.
because they cost too much.
Yeah,
Okay, very good. So are we good with this? You want to add this?
Yep.
Okay, Martin says yes.
Yes, I think it's good.
Sure.
Okay.
All in favor? I see 6 paws. We're good. All righty. Motion to adjourn.
So moved.
Second.
I'm glad Martin and Jim showed up.
When do we do this live?
Monday,
Oh,
Magic.
nice try.
the magic
do
date.
We do not have any cases that have been presented to us. One party asked Wendy when, or all bunch of questions about it, but they hadn't even gone to the town yet, and she doesn't even know what the town was, didn't ask, didn't want to know. So I don't know if that's still in the wind or what. Not going to worry about it. All righty,
Okay.
we're done.
Bye, guys.
Nice to
We're
see you
done.
all.
Thank you ever so
I
much.
know.
Appreciate you.